Hello and welcome to lecture 2 for topic 2. And in this lecture, we're going to take a look at limiting the power of the Supreme Court. Okay, so in our last lecture, we looked at the powers of the Supreme Court, and we spent the entire lecture learning about judicial review and Marbury versus Madison. In this lecture, we're going to take a look at the restraints on the power of the judiciary. And as I mentioned in the last lecture, the second half of chapter 2 deals with three main topics. One is Congress's ability to define the appellate jurisdiction of the Supreme Court, justiciability, and standing to sue. And so for this lecture, we're going to be focusing on the second and the third point, justiciability and standing. I'm going to leave it to you to read in the textbook about the way that Congress has the ability to define the Supreme Court's appellate jurisdiction. And I'd be more than happy in office hours or at any time to discuss the post-Civil War case called Ex parte McCardle, which is a pretty cool case, but we're not going to cover that in lecture. So let's take a look at justiciability and standing. Okay, so let's talk about the concept of justiciability. So one restraint that's placed on the power of the Supreme Court is justiciability. And what justiciability means is it asks the question about whether or not a case is appropriate for being reviewed by the Supreme Court, because not all cases are appropriate for review. And the Supreme Court cannot review a case unless it is justicable. And so we get this concept of justicability from Article 3. And in Article 3, which establishes the Supreme Court, Article 3 tells us, first that the Supreme Court has the power to hear all cases having to do with the Constitution, with federal law, really, anything having to do with relationships between states, maritime law, treaty law. And so, one aspect of Article 3 is telling us that the Supreme Court hears cases dealing with federal issues. Another thing that Article 3 tells us is that there are justiciability requirements beyond that the case must deal with a federal issue. One thing that Article 3 says is that there must actually be a case for the Supreme Court to hear it, to review the case. In other words, something must have happened, that there must be some action that took place that needs some sort of oversight or some sort of review. So there has to have a cause of action. There must be a case. Another thing that Article 3 tells us is that there must actually be a controversy as well. That there has to actually be a dispute between individuals or parties. So when you look at Article 3 and you read through it, you see the word case over and over again and controversy. And so that's been interpreted as to say that for the Supreme Court to hear a matter, it actually must be a case, there actually must be a controversy. So let's dig in a little bit more deeply to give examples of what that means. So your textbook identifies 5 characteristics of cases where justicability is a concern. They talk about the issue of advisory opinions, collusive cases, moot cases, cases that aren't quite ripe, and so the issue of ripeness, and also political questions. So these are the 3 characteristics that can raise some concern about whether or not the Supreme Court can actually review this case. And so let's dig into each of these 5 characteristics in more detail. Okay, so let's start with advisory opinions. And advisory opinions are pretty easy to understand. What an advisory opinion is asking the court, the Supreme Court, to offer an opinion on a hypothetical case, okay? So here's an example of a potential hypothetical case. Let's say, what if Congress passes a law mandating vaccinations for all employees and students in schools that receive federal funding? Would that be constitutional? Okay. So Congress has not passed that law. Okay. There's no law that Congress has passed saying that all school employees and all students who in schools that receive federal funding must be vaccinated. But maybe Congress is thinking about passing that law. Okay, maybe they're saying, we're thinking about passing that law, but we're wondering whether or not that law is in fact constitutional. Okay, Well, if you were to ask the court to rule on a hypothetical case like that, that would be considered an advisory opinion, ruling on a law that actually hasn't been enacted. And that would not be the kind of case that the Supreme Court could review. That would not be justicable. So as it says there, advisory opinions are not justicable. Why aren't they justicable? Well, because there's no case, right? There's no action that has taken place. A law hasn't been enacted. Nobody has been impacted by the law. It's hypothetical, right? So there's no case, and therefore there's actually no controversy, right? There's no controversy where a law is passed, and then like a teacher who works in a federally funded school is like, oh, I didn't get the vaccine. Now I got to get the vaccine or I'm going to lose my job, right? I'm being harmed by this law. There's a controversy that needs to be settled, okay? And so the court has said that advisory opinions, the cases that are hypothetical, are not justicable. Now, the Constitution itself doesn't explicitly forbid advisory opinions, but the court ruled early on that it wouldn't do it. For one, they said it violates the separation of powers, right? So, I mean, if the legislative branch turns to the court before it actually takes action, right, enacts a law, that basically it's asking the Supreme Court, the court, which is the judiciary branch, to sort of weigh in and advise the legislative branch. And that's a violation of the separate powers, right? The legislative branch enacts law or makes laws, the executive branch executes those laws, and then the courts settle disputes over those laws, right? They resolve, issues of constitutionality. For the court to advise the legislature before they pass a law and say, oh, yeah, that would be constitutional, or no, that violates the separation of powers. Also, hypotheticals are not real cases. I mean, you're imagining how that law might be implemented and the impact that it might have, but that we don't really know how that's going to play out. And so the court said that they're not going to deal with hypotheticals. They're only going to deal with real cases. And in fact, they have to, because Article 3 says cases and controversies. Now, some states and countries require judges to issue advisory opinions when asked, right? So in other countries and in some states in the United States, that if the legislature says, oh, we're thinking about passing this law, what do you think, courts, they actually have a legal obligation to do that. But the Supreme Court and the federal courts do not have that authority. And so maybe think about the benefits and the drawbacks. I mean, one benefit would be like, well, if a state or state's thinking about passing a law that could violate the Constitution, or the federal government is thinking about it, well, it's better to know whether it's going to pass, be constitutional, rather than wasting a bunch of time on it. On the other hand, though, because it's hypothetical, there's a lot we don't know in terms of how it will play itself out in the real world. And so there are some drawbacks associated with that as well. And there's a huge drawback in terms of blurring the lines between the judiciary and the legislative branch. All right, let's turn our sights now to collusive suits, because collusive suits they're not justicable. They cannot be reviewed by the Supreme Court. Okay, so sometimes people will create a case to challenge the constitutionality of a law. That happens, okay? And I'll give you two examples of when that happens and when it's allowable, when these created test cases are actually like justicable. And so, as it says there, the Supreme Court can hear sort of test cases as long as there's an actual dispute to be settled, okay? So let me give you two examples of cases that were sort of these cases that were intentional in order to basically challenge a law. And the two cases are Plessy versus Ferguson and DC versus Heller, the District of Columbia versus Heller. We're not going to be reading Plessy versus Ferguson this semester, but because it has to do with civil rights, but we will be reading District of Columbia versus Heller, which is the landmark case regarding the right to bear arms. In both of those cases, there were laws on the books. On Plessy, it was about a Louisiana law that said that African Americans had to ride in separate train cars than white Americans. And so African Americans had to be separate from whites. They had their own cars. And Homer Plessy, they knew about that law, and there were interest groups that worked to challenge that law. And so Homer Plessy got on the train, and then he, was fined for violating that Louisiana state law. DC versus Heller is also, there were these really restrictive laws in the book in District of Columbia, and there was an interest group that was wanting to challenge that law, and they handpicked a person, to basically violate that law, right? But in both cases, Plessy was harmed. Heller was harmed because he wasn't allowed to own a handgun. Plessy was fined for riding in an for violating the separate train cars laws. So those aren't examples of collusive suits. What a collusive suit is if the opposing parties are in collusion with each other. In other words, that they're cooperating together, like they're both on the same side, and that there's really no controversy that is going on. So if the opposing parties are in collusion, the Supreme Court has said they can't hear these cases. And why? They say, well, the collusive suits are not justiciable. And they're not justiciable because there is a case that's been created. So there's an action that's been taken. However, there's no controversy because both parties are on the same side. They want the same outcome. There's not any real adversity between them. They're merely testing the law. Now, in the case of Plessy, in the case of Heller, there was controversy, right? Heller really wanted that DC law to be overturned. Plessy really wanted that Louisiana law to be overturned. But if the parties are on the same side, they're collusion, there's no controversy. You can read about a collusive case, Muskrat versus the United States, in your textbook. That has to do with testing the constitutionality of a federal law about dividing lands, giving lands to Native Americans. And as you'll see in that case, the members of Congress wanted to test it, whether or not that federal law was in fact constitutional. And so they basically created a law allowing Native Americans to challenge that law, and in fact paid the court fees of Muskrat to actually sue the United States. So they were clearly in collusion, and the Supreme Court said those kinds of collusive cases are not justiciable because there's no controversy. Now, if a case is considered moot, then it is cannot be reviewed by the Supreme Court. It is not justiciable. And so that's because courts can only hear actual live disputes that are going on, are presently taking place. If there's no longer a dispute to settle, the court can't hear the case. Why? Because there is no controversy to settle, and they consider that to be moot. If a case is moot, it is not justiciable by the Supreme Court. There are a couple of cases that your textbook talks about in about whether or not a case is moot. They talk about DeFunis v. Odegaard and Roe v. Wade. And I put Craig v. Boren in here too, because I know that there's some students in this class that took my sex, power, and public policy class. And so I wanted to bring that case up because it's a good example of how they got around the issue of mootness. So in Craig v. Boren, for those of you who remember, and for those of you who don't, I'll just tell you a little bit about it. This was a case about equal protection under the law and whether it's okay to treat men and women differently in the law. And this was a case about age requirements for drinking beer. This was back in the day, the 1970s, where there was this thing called near beer, like low alcohol beer, like 3.2 beer. And some states had on their in their laws, they said that women could drink near beer at age 18, but men had to wait until they were 21 because it's like men are reckless and they need to be, like governed more or whatever. And men in the state where that law was on the books, and they cried foul. They said that law was discriminatory. Now, for those students who were in my class last semester, remember how that they had a litigant and that it took so long to get that case to the Supreme Court that the litigant was no longer 21. They were too old. So it was moot because it's like, hey, he's 22 now, he can go buy the beer. So they had to get another litigant who was under the age of 21 to keep the controversy alive, right? And DeFunis, they talk about that in your textbook, and this is basically a case, but a guy who applied to law school and he was denied admissions, and he said he was unfairly discriminated against. But it took so long for that case to work its way through the court that by the time it worked its way through the court, Defundus was 1 semester away from getting his law degree. And the court said they couldn't settle that case. Why? It was moot, that there was no longer a live dispute. Although one of the justices said, hey, he still had 1 semester to go, so it was still a live dispute, but the court didn't buy that argument. Roe v. Wade is another example of a case that could be considered moot, but the court said it was not. Roe v. Wade, we're going to be learning about it later in the semester. Most of you are probably already familiar with it, but Roe v. Wade is basically about whether or not a woman has a constitutional right to have an abortion. And in that case, that people are pregnant for 9 months, and it takes a lot longer than 9 months for a case to work its way through the lower courts and work its way up to the Supreme Court. And by the time that Norma McCorvey, that was the woman who wanted an abortion but couldn't get one because Texas law prohibited it, she had already given birth to her child. So one argument was, hey, it's moot, right? There's no live controversy. But what the court said was that in this case, that the law impacted a class of people. While Defundus, it was a case that was about his own individual discrimination. In Roe v. Wade, it affected a class of people, that is, women who can get pregnant. They also said that Norma McCorvey, Jane Roe, that she could have gotten pregnant again. So they said that they could still hear that case even though Roe had given birth because it was an ongoing controversy. Okay, so moot basically means that it's dead, right? There's no live controversy, right? The dispute doesn't exist because there's the controversies are, been settled. Either the person got old enough to buy the beer or the person already graduated from law school. Ripeness is the opposite of mootness. Basically, moot is saying that the dispute is no longer alive. Mootness or ripeness has to do with whether or not this dispute has happened yet. And so when we're talking about ripeness, usually the court will say, wait a second, that this dispute hasn't happened yet. You brought this to the court too early. And for a case to be justicable, to be heard by the Supreme Court, it's got to be a live dispute, okay? Now, unripe cases are similar to advisory opinions because it's sort of like, ooh, there's a law in the books, and we think somebody's going to be harmed by it, but they haven't yet. Okay, it's not a live controversy, but we want you to rule on it. But the court says, just like with advisory opinions, we're not going to rule on an unripe case because it's not yet a controversy. And you can read about the case in your textbook that gives a concrete example of an unripe case, which is the International Longshoremen's Union versus Boyd. This had to do with a federal law that said that if a person was going to go and work in Alaska, that they had to be treated as if they were and if that person wasn't a citizen of the United States, they had to get extra scrutiny to work in Alaska. And the International Longshoremen's Union was concerned because they had a lot of seasonal employees who were legal to work in the United States, but they were not, they were legal to work here, but they were not citizens of the United States. And they thought for those people to be treated as and go through extra scrutiny, they thought that was unconstitutional. The court said they wouldn't hear that case because that no one had tried to work in Alaska yet, that it was not yet a controversy. And so they dismissed that case, saying that it was unripe. The final justicability characteristic that we're going to talk about are political questions. And these are different from the other ones that we've talked about so far, but still that there are sometimes the Supreme Court will not review a case because it deals with a political issue or a political question. So another type of non-justicable suit involves what is deemed a political question. And the court basically says that these questions, that they may in fact involve a constitutional matter. However, it should not be reviewed by the court due to their political nature. And let's give a concrete example to help us understand the justicability as it relates to political questions. The example that your textbook uses is this case called Nixon versus the United States, and it deals with impeachment procedures. But it's not that Nixon, it's not Richard Nixon. In fact, Richard Nixon was never impeached. The Congress had, or the House had, submitted articles of impeachment, but that once Richard Nixon knew that he was going to be impeached, that he resigned before he was actually impeached from office. So Richard Nixon was never impeached. He actually resigned. This case, Nixon versus the United States, 1993, that's also a giveaway, has to do with a federal judge. His name was Walter Nixon. He lied before a grand jury. Hello, you're a judge. Why did you do that? And he was convicted of a felony. When a judge is convicted of a felony, then they can be impeached because, as the Article 3 says, that while you serve a lifetime, that a judge can be impeached if they engage in behaviors that indicate that they are not fit for serving on the federal courts. And so Congress exercised and Congress has the power to impeach both the president, but then federal judges, any federal a minister or actor can who holds an elected office can be impeached, or an appointed office can be impeached. And so Congress exercised their impeachment powers. They impeached the House impeached, saying that there was evidence that he had committed a crime, and then the Senate went ahead and removed him. So he basically lost his job. Walter Nixon was pissed off because that he felt like the procedure for impeachment and removal wasn't followed properly, and he wanted the Supreme Court to intervene and rule to say that that the Congress had acted improperly. And as you'll read in our textbook, the court said, nope, they're not going to review this. They basically said that the impeachment and the process for removal power, that's given to the Congress in Article 1. So that's their power. They also said that this is sort of more of a political issue in a way, and that if the court were to get involved, it would muddy it, it would bring about chaos, and it would also just sort of like anytime somebody would they would be impeached, they would call upon the Supreme Court to sort of settle the dispute around this political matter, a matter about politics and the powers that are given to Congress. And so that's a good example of like some cases the Supreme Court says, yeah, it deals with the Constitution, but that's a constitutional power that's given to Congress, and we're not going to get involved in that. Okay, so one way that the power of the Supreme Court is restrained is in terms of justicability, and that there are some times when, because of Article 3, the Supreme Court does not have the power to review a case, justicability. But there's another way in which the power of the Supreme Court is restrained as well, and it has to do with standing. So let's talk about what standing is. So the Supreme Court and other courts as well can only review cases in which the party that's bringing the case to the court has what's known as standing to sue. And what does that mean? What constitutes having the standing to sue? Well, for when a person brings an issue to the Supreme Court, they must demonstrate that they have been actually harmed by the law or harmed by an action that's been taken by like the executive branch. So like if the president engages in an action, or like the secretary of the Department of Defense engages in an action, and you feel like you've been harmed by it, then you must demonstrate that you've been harmed by the law or the action in order to have standing. You also the harm must be traced back to the person, the party being sued. So if you say you've been harmed by something, you have to demonstrate that what harmed you is related to the federal law or the state law or the actions of the president or some sort of federal executive. If you can demonstrate that you were harmed, but you weren't actually harmed by a law or an action that's under the purview of the courts, then you don't have standing. And then you also have to demonstrate that a favorable court decision is likely to address that harm, provide redress, right? So you've been harmed, and then if the court takes action, are you actually going to get like a remedy, right? So like, for example, if an example of having standing to sue is a case that you're going to be reading later in the semester that has to do with the freedom of speech rights of school children. Or people who are under the age of 18, and this actually took place in the school. It's a really cool case called Tinker versus Des Moines. Tinker versus Des Moines, as the date there suggests, took place during the Vietnam War, and this was a case about middle schoolers who decided that they wanted to wear black armbands to class in order to protest the Vietnam War. And the school district in Iowa, and that's where this takes place, said that if a student wore an armband to school, that they would be expelled. And Mary Beth Tinker, that's who the case is named after, and some other students wore their armbands to school, even though the school board said that they would get in trouble if they did that. And they were, in fact, expelled from school. And so that's a really good example of having standing to sue. Mary Beth Tinker and her parents, because she's needed an adult to bring the case, and they're her guardian, and that's fine. They basically said that their child was harmed by the law. They wanted to express themselves, and that school children have a right of freedom of speech, and that their actions didn't disrupt the school, and so they had a right that was violated, and also that they were harmed by that right, that the law that violated their rights, because they were expelled from school. And that if the Supreme Court ruled that action of the school board expelling students who wore armbands violated the First Amendment, spoiler alert, they said it did violate the First Amendment, then the Tinker family and Mary Beth Tinker would, that the favorable court decision would provide redress, right? That it illustrates that students do have a right to speak, and that, the expelling from school was erased from her record, right? So that's a good example of standing to sue. Let's take a look at a case where there was no standing to sue. Okay, so while Tinker versus Des Moines is a good example of somebody who has standing to sue, and it deals with the civil liberty that we're going to be talking about in a few weeks, this case, the Elk Grove Unified School District versus Newdow, it's a good example of an issue that deals with civil liberties, but where the court found that the person bringing this case, the Michael Newdow, that he didn't actually have standing to sue. So they said that even though they granted this case a writ of certiorari, when it came to deciding it, they said that they couldn't review it because that Michael Newdow did not have standing to sue. Let me tell you a little bit about the facts of this case because it's interesting. It has to do with the Pledge of Allegiance. And so Michael Newdow's child went to a school, and the school said that every morning that they had to stand and recite the Pledge of Allegiance. And that Michael Newdow was an atheist, and he did not want his daughter reciting the Pledge of Allegiance because the Pledge of Allegiance says that you have to say one nation under God. So they basically said that was a violation of the Establishment Clause because it was basically a public school that's paid by taxpayer dollars is endorsing or favoring a religion by making all students say one nation under God. Okay. And so he sued the school district for a violation of the religious clause in the First Amendment that says that Congress shall make no laws establishing a religion. Okay. And he said that this violated the Establishment Clause, which we'll learn about more in a few weeks. So he brought that case to the Supreme Court, and the Supreme Court said that Michael Newdow didn't have standing to sue. You might be like, why not? He's the daughter of a child, just like with the Tinker case. His daughter was harmed, so he's the guardian, then he has standing to sue. Well, as it turns out, Michael Newdow was divorced, and that his wife actually had custody of the child. And so that while he was able to see his child and had a relationship with his child, he was not the custodial parent. So he didn't make decisions about where that child went to school. And so basically that since he wasn't able to make those decisions for his daughter, he didn't have that kind of custodial care over her, that he can't lose something that he never had. In other words, he can't say, hey, I want to send my child to the school, but they're forcing her to say the Pledge of Allegiance, and I'm harmed by that. The court said, you know what, dude? You're not harmed by that because you are not the custodial parent. You can't lose something that you don't have. And so they threw the suit out saying that he didn't have standing to sue. Again, sometimes the Supreme Court can make your head spin because it's like these little details. The interesting fact is that the Supreme Court has never picked up another case dealing with the Pledge of Allegiance. So we still don't know whether or not the provision, one nation under God, violates the Establishment Clause. All right, thanks for sticking around for this lecture. These first several chapters, like I said, have to do with like the foundations that, that are really important to understand, because these issues will come up about justicability, standing to sue, whether it's a case, whether it's a controversy, whether it's moot or ripe, etc. Those issues will come up as you're reading cases, and these lectures in these chapters will allow you to get a more full understanding of the cases. Thanks for your time, and I'll talk to you again next week.